everyone, my name is Vivian Gu. I'm a founding partner of We Law Firm. Today, I'm joined by David Anderson, an experienced employment law attorney who focuses on working with companies on challenging the employment issues. Good afternoon, David.
Hi, Vivian. Good afternoon. I'm so glad to chat with you today about some of the employment law needs that companies frequently ask me about.
Yes, it can be very challenging to be an employer, particularly in California, where there are so many different laws and regulations that employers need to understand. For example, their worker classification, wage and hour laws, discrimination laws, workplace safety laws, privacy laws, etc. What is the top issue that employers seem to struggle with?
You know, Vivian, all of the issues that you just described come up frequently. But in my experience, a lot of employers have a really tough time figuring out and complying with worker classification issues. You know, this issue can really dictate how an employee is paid or versus an independent contractor is paid. It can have real consequences. So let's talk a little bit about it. With respect to worker classification, employers need to be very careful when they make a decision about whether to classify a worker as an independent contractor or an employee. The penalties for misclassification for making the wrong choice here can be very, very large. In California, after the passage of AB 5, employers are now required to apply the so-called ABC test, like the letters. The ABC test is used to determine if workers in California are employees, or independent contractors. And this is for the purposes of how they're treated under the California Labor Code, unemployment insurance, as well as the IWC wage orders, all very important laws and regulations for California employers. Now, a little bit about the ABC test. Under the ABC test, a worker is considered an employee and not an independent contractor unless the company can show all of the three following conditions. One, the worker has to be free from all control and direction of the company in connection with his performance of the work, both in the terms of the contract, but also in fact. Second, in order to classify a worker as an independent contractor, the worker must perform work that is outside the usual course of the hiring entity's business. What this usually means is if there's another worker for the company that is classified as an employee who does the same exact work as the worker, then it's going to be difficult to meet this test to classify that worker as an independent contractor. Third factor, the worker is customarily engaged in an independent established trade, occupation, or business of the same nature as that involved in the work performed. Usually what this, some of the evidence that employers need to show here is that the worker, to be classified as an independent contractor, has other clients, maybe works in his or her own LLC or C Corp, something that shows some legal separation between the company and the worker. You know, without question, this is very sophisticated, significant, detailed analysis. So in my opinion, companies are well advised to consult with an attorney before making any classification decisions about any workers.
Thank you so much. Yes, it is a very difficult aspect of law. I know the California Labor Commission routinely promote performance audits of companies when current and former employees file complaints. Perhaps even more challenging are when current and former employees file their own lawsuits for misclassification claims. What's another issue that you see commonly?
Yeah, you know, one of the big issues is compliance with wage and hour regulations, and meal and rest breaks in particular. These can be very challenging for employers to get right. Employers will always benefit from working very closely with an attorney or a very experienced HR professional in California to set up legally compliant and defensible timekeeping and meal and rest break systems. Another hot topic right now is sexual harassment, particularly around the Me Too movement. Many employers are unaware that nearly every employer in California is required to train its entire workforce on sexual harassment prevention every other year. I personally, I have led anti-discrimination, anti-harassment trainings, and they're very helpful for employers and their management to promote a safe, harassment-free workplace.
Right, and I understand that if an employee does file a sexual harassment complaint, a company may have to conduct a neutral, thorough, and prompt internal investigation into the complaint, or risk automatic liability to a company, even if it has done nothing wrong.
That absolutely may be the case. And, you know, too often in my experience, companies just try to, you know, handle complaints. You know, they have the owners or the supervisors talk with the parties involved and leave it at that. That is very well likely in some cases not to be sufficient, particularly for more serious complaints. There needs to be a neutral investigation done by somebody who is experienced in handling these. And it's critical that companies consult with an experienced attorney, you know, as soon as they receive any evidence of a credible workplace complaint.
Wow, that sounds like it could really cause a lot of trouble and headache to the company.
Yeah. Well, there certainly is a cost to properly handling an investigation, and I think we all know that. But the cost of not properly handling an internal complaint may be actually much, much higher. You know, what I like to share with my clients is an internal investigation is actually an opportunity to learn about the current state of the workforce. And hopefully improve it after the investigation completes. This can be a real benefit, actually, to the long-term health of a company's workforce.
Well, that is a perspective that I'm sure employers will be interested to consider. David, this has been a very interesting discussion of some of the more challenging employment law issues employers face right now. I would encourage employers who are facing these types of issues to reach out and learn more about how we can offer legal services to help with these challenges. Thank you for your time to talking about this today, David.
Thank you so much, Vivian.
Thank you.